All right, welcome to the continuation of the hearing on the Kansas Court of Appeals. And I'm your presiding judge, Mike Boozer, and joining me is Judge Hill, and also Judge Isherwood is joining us as the third member of the panel. At the start here, I need to figure out who these other people are because I don't have your names on the docket. So for Dr. Is it Sajadi?
Yes, Your Honor.
Okay. Mr. Keller, are you, did you do the brief on this?
I did not, Your Honor. I entered my appearance after the brief was filed.
All right. So you have an entry of appearance on file?
Yes, Your Honor.
And just for fun, could you give me your bar number?
I absolutely can. It's 22564, Your Honor.
22564.
Yes.
Okay. And that's Russ Keller. All righty. And for the Kansas Board of Healing Arts, we have Tucker Poling.
Correct, Your Honor.
All right. I've got you down. So, okay, gentlemen, we have the case before us today, Dr. Sajadi versus the Kansas Board of Healing Arts. It's set for 30 minutes. You have 15 minutes aside. If Mr. Poling, if Mr. Keller, if you would let me know how much time you want in reserve, I'll give it to you.
I'm happy to do that, Your Honor. We are technically the appellee, and I'm happy to go first, but Mr. Poling may have been expecting to go first.
Good point. Judge Boozer made a slight mistake. Mr. Poling, how much time would you like for rebuttal?
I'd like 5 minutes, Your Honor.
Okay. You've got it. It'll be 10-5 for you and 15 minutes for Dr. Sajadi. All right, Mr. Poling, please begin.
May it please the court. The question before this court is whether Dr. Sajadi meets his burden to show that the sanction issued by the board was so arbitrary, capricious, or unreasonable that he overcomes the presumption of validity given to the agency action and the deference given to the professional expertise and experience of the board under Kansas law. The reason we've brought this case to you is that the district court erred by substituting its judgment for the board's on an issue of clinical patient safety. And we believe such errors have the potential to set a dangerous precedent if not corrected. This appeal arises out of a professional disciplinary action taken by the Kansas State Board of Healing Arts against Dr. Sajadi. The board's sanctioning authority is defined at KSA 652836, which lists 65 grounds that can trigger the board's sanctioning authority. In this case, the board's sanctioning authority was triggered because Dr. Sajadi was disciplined by the Missouri Board of Healing Arts. Once the board's sanctioning authority is triggered, the statute authorizes the board to revoke, suspend, or limit the license. The only limitation outside of 2836 on that sanctioning authority relevant to this case is contained in KSA 77621C8, which prohibits board actions that are so arbitrary, capricious, or unreasonable that they may be rendered invalid by a reviewing court. In this case, the district court overruled only one aspect of the board's final order, and that was one of the three sanctions that the board issued. The three sanctions issued by the board in this case were 1, a censure, 2, a fine, and 3, a practice limitation to protect patient safety that requires Dr. Sajadi to stay available for follow-up care for 24 hours following a surgery, have a written backup coverage protocol, and have admitting privileges at a hospital in the area where the surgery occurs. Now, it was this third sanction that the district court overruled. So the one aspect of, Judge Hill?
Counsel, I had a fact question before you get deep into your argument about the merits. As I understand it, the action against the doctor in Missouri was based upon an occurrence in Springfield, Missouri, where he had an office. And he did a liposuction there and left, and things went bad and wasn't within reach and all of that. It's all in the record. but it's my impression, and I can't find it again. He has since closed his practice in Springfield.
Your Honor, my understanding, I don't know that that's in the record one way or the other. My understanding is that he has closed one of his practices. I'm not sure if it's the one in Springfield.
All right. Well, my question is relevant to the, if I remember correctly, there's he should be within 20 minutes of away, and if you live in the metropolitan Kansas City area, it's certainly going to take you longer than 20 minutes to get to Springfield, Missouri.
Right, and that's one of the problems that the board had in this case, is that when you are traveling outside, when you are traveling somewhere to do a surgery, and then you leave after the surgery and you don't stay around where you're available for 24 hours for follow-up surgical care, the board found that problematic, as described in the final order. And
did the district court then explain why that should be deleted, that sanction be deleted?
It did, Your Honor. The district court, the one aspect of the board's final order that the district court overruled was the practice limitation, and that's the one aspect that most directly related to clinical patient safety and falls most squarely into the area of expertise of the board. And what the reasoning that the district court had for deleting that practice limitation was one of the things that compounded the error in this case, because what the court did was it applied three novel and problematic factors that are not based in Kansas statutes or case law, that are in fact in tension with Kansas statutes and case law, and that do not demonstrate that the board's final order was unreasonable in this case. Now, notably, there are factors that have been outlined by this court in Wheatland Electric Co-op versus Polanski to help district courts evaluate reasonableness under 77-621C8. But it's telling that the district court did not apply those factors in this case. What this court said in Wheatland about district courts reviewing for reasonableness under 621C8 was that, quote, courts must be careful in making this review because the legislature has given the discretion to make the decision to an agency, not the court, end quote. But here, the district court didn't follow this court's admonition to be careful in reviewing an agency decision under 77-621C8. And in fact, instead of applying those Wheatland factors suggested by this court, the court created three of its own factors. Now, those are cited in our brief, and I won't repeat everything that we said in our brief, but I do want to focus on two of those factors that the district court relied on and hopefully add to what we've said in our brief. One of the factors that the district court relied on to overrule the practice limitations in the board's final order was consistency between the sanction imposed by the other state, in this case, Missouri, and the sanction imposed by Kansas. Now, there are a few problems with that. One is that that conflicts with some of the basic assumptions in our system of federalism that assumes there will be variations between states in the exercise of police power, especially in the area of public health and safety. But what I want to point out here in this oral argument is that this factor, this idea that there should be consistency between what the Missouri board did and what another state's board does, in this case, Kansas, is that this is also in tension with the legislative intent of the relevant statute here in Kansas, which is 65-2836, which does not contain any language that suggests the type of limitation suggested by the district court. The legislature could have included language that limited the board's sanctioning authority when the trigger for that authority is a disciplinary action by another state, but it chose not to do so. And in fact, the legislature very recently demonstrated that it can do that. It did that this past legislative session when it passed HB 2066, which was signed by the governor. And if it's not law now, it will be law any day now when published. But that is a statute that was passed this past spring that creates essentially a fast track licensure process for a certain type of applicant from out of state They can come to Kansas, and based on their license in another state, if they have no history, if a number of factors are met, they can get a license in Kansas a little faster and a little easier. But the legislature also said, if you get this license, if you are sanctioned in the other state, the Board of Healing Arts can sanction, but it has to be the same sanction that the other state issued. The legislature did that in HB 2066 subpart.
Well, what's your best argument for telling us where the district court got it wrong?
Well, the district court got it wrong by substituting its judgment for the board. As the cases cited in our brief state, the Kansas courts have repeatedly stated deference should be given to the board, especially in an area of expertise that is in the wheelhouse of the administrative agency. The district court didn't follow the Wheatland factors and followed factors that are in and of themselves problematic. I noted the problems with the factor of suggesting that not being the same discipline as the other state suggests a lack of reasonableness. Another very problematic factor that the district court applied was saying that inconsistency between the summary order that was issued in this case and the final order that was issued in this case, meaning that the sanction issued by the final order contained a limitation that was not in the summary order, that lack of identity should suggest a lack of reasonableness. And this conflicts with the statutory structure created by the legislature in 77-537. And I think this is a point on which both the appellee and the appellant agree. The summary order procedure set out in 77-537 is essentially a procedure by which the board staff drafts an order that is a proposed order. It contains stock provisions, but either party can request a hearing. And when you do that, that summary order is given no deference. So if you request a hearing, the summary order is given zero deference, and the statutory structure clearly sets that out. And you get a hearing before the board, which is completely de novo. No deference should be given to the summary order. But the district court suggested the opposite, that if you're not consistent with the summary order, you do something different. That's a factor that can be used against you to suggest unreasonableness under 77-621C8. So basically, the legislature is saying the district court is saying the opposite of what the legislature has said in 77-537, and that what the district court did in itself conflicts with the Wheatland factors, because one of the Wheatland factors is that one thing that can suggest lack of reasonableness is if you consider a factor that the legislature did not intend you to consider. And what the district court is saying is you should consider this factor that the legislature has said you shouldn't consider.
Mr. Poling, I thought one of the better arguments that or rationales that the district court used was that the guidelines for the imposition of disciplinary sanctions put out by the board recommends parallel action with whatever the state punishment is. Could you address that?
So the problem with that is that the district court elevated what is guidelines that suggest common sanctions that can apply and that are clearly stated on the face of the document, not intended to limit the board's authority, that simply provide information to stakeholders as to considerations the board commonly applies. And so the common sanction listed on page 12 of those guidelines, lists parallel the other state's action as a common sanction. Now, the fact that it's a common sanction doesn't mean that when you don't do exactly that, it's unreasonable. And that's essentially what the district court held in this case.
Isn't there also language adjoining that table that you referenced on page 12 that basically just says this is not to be an analytical guide, but rather the board should analyze each case basically independently?
Absolutely. And those provisions are not buried, they're bolded. We put in our brief, that it was in bold letters. This is not something that limits the board's discretion. It's just to give stakeholders an idea of the general types of sanctions that are commonly applied.
So it's like a jumping off point as opposed to.
Right. I think that's a fair statement. It's a jumping off point. Now, if there was no record in here, if there had been no hearing, and we had just done something different than Missouri without any rhyme or reason, without any having any additional discussion of the facts or a hearing, it might be a little bit different argument. But the guidelines, are just information to give people an idea of the type of things that the board often applies in these cases.
All right, you've got 30 seconds if you want to use them. You don't have to.
I think I will defer the remainder of my argument to my rebuttal.
All right, very good. Mr. Keller?
Thank you, Your Honor. Again, Russ Keller on behalf of the appellee, Dr. Sajadi, in this case. And Your Honor, the central problem in this case is that the board imposed the practice limitations under discussion without providing notice or evidence that Dr. Sajadi's treatment of the Springfield patient dipped below any medical standard of care. And this core problem creates three overlapping reasons why the practice limitations are arbitrary, unreasonable, or capricious under the Kansas Judicial Review Act. The reasons are the limitations weren't accompanied by sufficient notice, they weren't supported by sufficient evidence in the administrative record, and they weren't supported by sound logic. So if we take those three reasons sort of in chronological order, the first problem is the notice problem. And as the court knows, there is a particular statute that governs the notice that has to be given. That's 77-518. Part A of that statute says you have to provide reasonable written notice. Part B then anchors that to any pre-hearing order. It says you're supposed to provide a pre-hearing order, which in this case was the summary order. So when Mr. Poling mentioned the procedure of what happens to a summary order once you request a hearing, we don't dispute that. But it remains true that under the notice statute, the summary order plays a role in the notice that is given to the respondent. And likewise, if you go down in the statute to section C7, this is again 77-518, that says to the extent not included in any pre-hearing order, then there has to be notice that provides a statement of the issues involved and to the extent known to the presiding officer, the assertions of the parties. So taken together, those provisions mean that a respondent has to be notified of the particular charges against him so he can prepare and then defend those charges in any administrative hearing. And we've
did the doctor contemporaneously object in the board to that lack of notice?
There wouldn't have been any way to do that, Your Honor, because we went to the hearing based on the notice that was provided, which again focused on the summary order. So we went into the hearing with Dr. Sajadi and his counsel, expecting this to be, essentially a copycat provision. Here's what happened in Missouri. That's, been essentially agreed to that the Missouri took this action. And then the board charged Dr. Sajadi in that summary order with subsection J of 65-2836. And that, of course, is the provision that says if you're subject to discipline in one state, you might be subject to discipline here in Kansas as well. But significantly, and so to answer your question, Your Honor, I do want to talk about that statute some more. There wasn't a contemporaneous objection because at that point there wouldn't have been anything to object to. We went into the hearing based on the notice that we had been provided, and we litigated the case based on that notice.
And there was no discussion about possible regulating of his practice of medicine?
Well, the historical facts, as recited in that Missouri order, certainly were part of the summary order, and you can see that in the appellant's brief in this case as well. But as we were getting to the 65-2836, there's a specific subdivision, Part J, which deals with discipline imposed by another state. There is another provision of that statute, Part B, that deals with professional incompetency or otherwise unprofessional conduct. That was not charged in the summary notice. And had that been done, then Dr. Sajadi and his counsel would have litigated the more complex and disputed factual issue of whether his treatment of the Springfield patient dipped below any medical standard of care. But that wasn't done. And in fact, the board sent to Dr. Sajadi a couple of hearing notices that said, this hearing is going to be, quote, on regarding the summary order, end quote. And
counsel, let me stop you there for just a second. Could the Kansas board even considered what he did in Missouri, other than by the subsection J, which I think is the one that says, if you've been disciplined in another state, we can discipline you. In other words, can he be disciplined in Kansas for something he did in Missouri?
he can be disciplined in Kansas if he was subject to some discipline in another state. So I think the answer to the question is yes.
So only if Missouri had disciplined him could then the Kansas board do anything with him, and that's based upon subsection J.
Correct. And he settled the Missouri action, to avoid larger costs, and it resulted in
and that gets me to another question, because I asked your opposing counsel. It's my impression that he ended his practice in Springfield. He closed his practice in Springfield. Am I incorrect in that?
Your Honor, I took note of your question and I was searching through my notes. I'm not sure if that's in the record or not. What I do know is in the record is that he did testify at the hearing in the Kansas matter that he no longer does liposuction. So he doesn't do that procedure anymore. I can't tell you of whether the status of the Springfield practice is in the record or not. I'm not sure at this moment.
All right. Now, the question that I have about that, because it goes to the reasonableness of the Kansas order that the Board of Healing Arts did. If he is not doing a practice in Springfield anymore in Missouri, there would be no requirement for Missouri to put a limitation upon him like Kansas did. Correct?
That's right. I mean, if he were practicing in Missouri, then you would think that it would be impossible to have a reciprocal limitation in Missouri that you have to be 20 minutes from the site of the surgery and so on. Yeah. I think that's right.
So there's no reason for the Missouri board to do it, but if he's continuing to practice in Kansas, is it reasonable for the Kansas to do that? Isn't that the question that's before us?
That's right, Your Honor. But the reason that these limitations are unreasonable, again, it doesn't depend on or doesn't pivot on whether Dr. Sajadi is practicing in Missouri or Kansas. Obviously, they apply if he's practicing in Kansas. It goes to the notice he had before those sanctions were imposed, whether they're supported by the evidence and whether they're supported by logic. So I hear what you're saying, Your Honor, but the sanctions should be, the district court should still be affirmed in eliminating those sanctions because they don't.
I'm really referring to the substance of the Missouri complaint. He left the patient, he wasn't within 20 minutes, and things went sour. And it looks like to me, the Kansas board is trying to say, we don't want anything like that to happen in Kansas, so don't do that. Am I getting this wrong factually? Isn't that basically what happened in Missouri? And so they're trying to prevent that from happening in Kansas?
I think that's a fair characterization, Your Honor. But I suppose the point we're trying to make is that the genesis of those sanctions, or the practice limitations, I should say, those come from, as you've just alluded to, what happened in Springfield, Missouri. And there has never been a showing, nor was there ever any notice that the historical facts are recited, but there's no evidence that any of that dropped below any medical standard of care. And that's how the sanctions or the practice limitations came about in the first place. And our point is that was invalid under the Kansas Judicial Review Act because it doesn't meet those various, C7 and C8 factors under the statute.
Mr. Keller,
Yes,
I'm
sir.
sorry, were you finished answering?
Yes.
Okay, I have a few questions for you. First of all, on the notice, didn't Dr. Sajadi and counsel receive a scheduling notice for the conference hearing on this matter? Okay, and doesn't that notice indicate, well, it includes everything from the summary order, and doesn't it indicate that summary order is subject to amendment?
Sure. But the baseline, I'm sorry if you were continuing with your
No,
question.
I was just going to say, so how does that not satisfy a notice requirement as far as he is subject to notice for that sanction?
Well, because in theory, you could amend the summary order in any of, countless infinite ways. I mean, you have to have some idea going into the hearing what exactly you're being charged with, or what the remedial, solutions may be to the conduct that has in fact been charged, and that didn't happen. And again, as I noted, I mean, you're right that the language in the hearing notices is not exclusive in referring to the summary order, but it does reference that. And it goes on to say, by the way, Dr. Sajadi, this is a quote, typically conference hearings last less than half an hour and do not involve complex disputed factual issues, end quote. So that's the notice, that Dr. Sajadi and his counsel received and headed into the hearing. And then, by the way, Your Honor, at the hearing, Dr. Sajadi and his lawyer show up for the hearing. The board's attorney confirms on the record, quote, "We are here to seek approval for a summary order," end quote. And then the board's attorney at the hearing multiple times says, "What is being sought in this proceeding is a public censure and a fine." These same types of sanctions, that we saw in Missouri as a result of the settlement order. And beyond that, the board's attorney at the hearing made clear that the board wasn't seeking to relitigate the.
But they're not bound by that. They're not bound by what their attorney proposes. That body makes its independent decision, correct?
They're not bound by it, but it goes into the notice that our client had heading into the hearing. And then at the hearing, we can't fight a charge or a proposed remedy if the board's attorney never even brings it up. And that is what happened, Your Honor. These practice limitations were never discussed at the hearing, not at all. They weren't even proposed. In fact, as I just mentioned, the board's attorney said we're only seeking the same types of penalties that Missouri imposed, a censure and a fine.
Another question that I have for you, when you answered the question with respect to the details surrounding the Missouri sanction, am I interpreting your answer correctly that you are suggesting that the board is prohibited from considering the underlying details of that sanction and that they may only consider the existence of a sanction? Is that what I understood you to say?
No, and this my answer to this will be a little bit nuanced, so I hope it works, Your Honor, but let me give it a try. I'm not saying that the board can't consider what is in the Missouri order. And as the court knows, and as Mr. Poling has ably pointed out in his brief, I mean, the Missouri order does have a recitation of some historical facts. And of course, we haven't fought those facts. They're in the Missouri order. We're not here to, fight those. I will say, though, the board in this case didn't enter that Missouri order into the administrative record. It's not there. They don't even have the administrative record there. But beyond that, what's missing, even with that recitation of historical facts, which I think the board can consider, is any evidence, let alone any argument, that those historical facts relating to the Springfield patient violated any standard of care. And in fact, the record in this case consists entirely now of 8 pages of testimony from Dr. Sajadi himself, who again goes over some of these historical facts of what happened in Springfield. But as you might imagine, since Dr. Sajadi is the only one who testified at the hearing, I mean, that testimony does not show that there was any medical negligence or incompetence, let alone gross negligence. It simply recites the historical facts. That's all that is in the record currently before the court.
If he did nothing wrong, why did the Missouri impose a fine and a sanction?
Yeah, Your Honor, no one has unlimited resources. Our client is no exception to that. And our client certainly could have fought to try to remove any penalty in Missouri, take the full hearing, more expense, more admission of evidence or preparation admission of evidence. But our client chose to settle that matter largely for administrative convenience, and in part because, the penalty coming out of that was something that the client could live with, a minimal fine, and then a public censure, and then you have to take a continuing legal education class. So that's more of a practical answer to your question, Your Honor, than a legal answer. But it's the truth. That's the reason that our client ended up doing that in Missouri.
I had one other question for you, Mr. Keller, and this kind of goes with the timing of the sanction from the sister state and why Missouri may not have imposed this. Wasn't their sanction a year almost before the Kansas sanction? And at that time, wasn't his Springfield office still in operation?
I think you may be right, Your Honor. And this gets back to Judge Hill's question. I don't have at my disposal the date or a record site for the status of the Springfield practice, but you may very well be right about that. Very good. Absent any other questions on that topic, I'll just, try to use the rest of my time to briefly summarize the last two reasons why the practice limitations are inconsistent with the Kansas Judicial Review Act. Reason number two is the factual portion of the order. And again, at the hearing, the board's attorney submitted no evidence to establish any violation of any medical standard of care. I mean, the closest anyone came to doing this was when one of the members of the board judging the matter made a reference in a question while Dr. Sajadi was testifying to this itinerant surgeon standard from the American College of Surgeons. And he specifically referenced the American College of Surgeons. But the board submitted no evidence to establish the existence of that standard or to establish that that standard applies to all licensed Kansas physicians, even the ones that aren't members of the college, which, by the way, accurately describes Dr. Sajadi. And even if they had put in evidence on that, there was no evidence to show that what Dr. Sajadi did violated that standard. So again, the entire evidentiary record is 8 pages of testimony from Dr. Sajadi, which is largely favorable to him. Last, Your Honor, the practice limitations are improper because they are based on faulty reasoning. And you heard, some discussion from Mr. Poling about new factors, not the non-Wheatland factors as he characterized them, but that's not actually what happened here. As the court knows, if an action or an order is arbitrary, capricious, or unreasonable, then it doesn't pass muster under the Judicial Review Act. And all the district court did here was apply basic logical factors, citing some evidence in the form of things like guidelines to show these are not reasonable. That's all the district court did. There's no invention of factors going on in this case. And really, I'm sorry, Your Honor. Was there a question? Okay, thank you. I didn't mean to interrupt. And really, there are two components to this faulty logic argument. The first component is that the practice limitations don't match the case the board actually presented at the hearing. The board could have sought and presented medical records relating to the Springfield patient and to Dr. Sajadi's treatment of that patient. They didn't do that. The board could have tendered an expert to opine what the standard of care was and that Dr. Sajadi dipped below that standard of care. The board did not do that either. In fact, there was no even request at the hearing for practice limitations. So after the hearing was over, that's when the board sua sponte decided to impose such limitations after the hearing had concluded and Dr. Sajadi could not say anything else. As the district court observed, Dr. Sajadi, quote, was sanctioned for being sanctioned, but was penalized based on the underlying facts of the sanction for which he was being sanctioned, end quote. The other component of the faulty reasoning, Your Honor, is what everyone has touched on earlier relating to the guidelines. The board departed from the common range of sanctions as reflected in those guidelines. Now, are those guidelines binding? Of course they are not, and we're not here to argue otherwise before you today, Your Honor. But those guidelines are made available to all prospective litigants, including Dr. Sajadi. He received a notice that directed him to those guidelines and said this contains information about how the board generally approaches the determination of appropriate discipline. And if you look at the table, as Mr. Poling alluded to, when you're charged with subsection J of 2836, there's a section in the table that says, the common range of sanctions for that is whatever the original state did. Is that binding? Of course it's not. But it does go to show, as the district court pointed out, that there's illogic to the practice limitations chosen by the board in this case. And that's all the district court was doing there. And let me maybe perhaps conclude the primary presentation here with this thought. There's no doubt, Your Honor, that the board has and should have an ample amount of discretion in choosing a remedy once some violation of the disciplinary code has been established. I mean, that makes perfect sense. These are medical issues, as Mr. Poling has pointed out, and we have a board consisting of physicians with some medical expertise. That's all true. But in the end, the board is not the final arbiter of whether its own order is arbitrary, unreasonable, or capricious. The court is. And of course, that flows from the Kansas Judicial Review Act. That's 77-621, the subsections of Part C that we've discussed before. So in other words, yes, The board has ample authority under 65-2836 in the preamble Mr. Tucker or Mr. Poling mentioned that, there's a variety of sanctions that might be imposed once a disciplinary, code violation is found. But there is always something circumscribing, the choice of which sanction, and that is the Kansas Judicial Review Act. And here, the board did not follow that. It imposed practice limitations that weren't supported by notice, they weren't supported by sufficient evidence, and they weren't supported by sufficient logic. And so for those reasons, Your Honor, I was about
Thank you, Mr. Keller. Your time has expired.
Thank you.
Mr. Poling, I am going to generously give you an extra 2 minutes on top of your 5 due to Mr. Keller's long-windedness, which was informative, but it went beyond his time limit. So I'm going to give you a little extra time too. You got 7 minutes starting now.
Thank you, Your Honor. And for the record, I do not find it long-winded. But
okay. Nice collegiality. Very, very good point.
And a very interesting discussion. Okay, so the notice issue. Boy, we couldn't take more exception to the appellee's position on that. I'm going to try not to repeat everything that we've said in our brief, but there are multiple authorities cited in our brief on this notice issue. But let's look at the record. Page 18, volume 1 of the record is the notice of conference hearing that says the issues to be determined in the conference hearing is whether to uphold, amend, or dismiss the summary order and or take other action authorized by the Healing Arts Act arising out of the issues and circumstances described in the summary order and briefing submitted by the parties. There's no debate here that the circumstances described were contained in the summary order. They're also, in the final order. If the court looks at the final order in the record, which starts on page 27 of volume 1, you can see that those same circumstances are outlined in the final order. Those have never been in debate. Mr. Sajadi's counsel stated, I believe it starts at page 43 of the record in the hearing, that the facts are not in dispute. Those facts that were in the summary order, those circumstances that we said this hearing is going to be about, those circumstances are contained very clearly, and they've never been in doubt. And it's about the circumstances of what he did in Missouri, and he testified about it. Judge Hill.
And does the Kansas board, is there any legal limitation upon the Kansas board that they have to consider and enforce the identical limitations or sanction that the Missouri board did?
Absolutely not. And as I mentioned in the first part of my argument, the legislature has demonstrated that if it wanted to create that type of limitation, it could have in 2836. It didn't, because it did in HB 2066, which was just recently passed. The legislature didn't require the two to be proportional.
And we all understand about notice, about being blindsided. And I think we all have been there one time or another in our legal careers, being blindsided by somebody. Was the doctor blindsided here?
Absolutely not. As I've stated, if you look at the record, beginning on page 27, again, appellee in their brief to this court states that they've never disputed those facts. It sets out the facts of the circumstances of what happened in Springfield. And so we sent out a notice saying the issues and circumstances are going to be an issue at this hearing. So he comes to the hearing. The first thing that Dr. Sajadi's counsel does is go into 4 pages of transcript talking about those facts, those underlying circumstances. So obviously everybody knew those were the issues. And so the idea that he was surprised that he was going to be sanctioned based on that underlying contact, frankly, I find that it's disingenuous, I believe.
And that was the only sanction on the table, correct? It's not as though it was that and, 2 others. The only thing they were there to discuss was the Missouri sanction. Is that correct? So it could have been anything involving that Missouri sanction?
They were there to discuss what was noticed up in the conference hearing. And again, what was noticed up in the conference hearing is all the facts that were described in the summary order, which describes the underlying conduct that occurred that led to the Missouri settlement. That's what we were there to discuss. Now, the trigger for the board's sanctioning authority is the sanction in Missouri. That's the trigger. And so once there's a trigger of the sanctioning authority, the next question is, what's the limits of the board's authority to sanction? And that's in 77-621C8. And it has to be so arbitrary, unreasonable, or capricious that it renders the order invalid. And they could.
Well, my point was, it's not as though he was there on a sex offense or an alcohol violation. Everything was going to be focused on this Missouri issue.
Correct. And again, we started the hearing, and his attorney goes into those very circumstances for multiple pages, and he testified at some length as to those circumstances. Opposing counsel suggested that our sanctions were not tied to the record. Our sanctions are directly tied to what he testified to at the hearing, which is in the record. He testified he had no backup, he had no protocol in place in case the patient couldn't reach him, and he was over 2 hours away, so he couldn't have returned. Had the patient needed to return immediately to surgery, he couldn't have done that. He testified to that. So our sanctions were directly related to what he testified to at the hearing and what was noticed up for the hearing. Now, there's been some discussion about, well, we should have had a fuller hearing. Again, if you look at page 18, volume 1 of the record, it states in the notice, any objection to this matter proceeding as a conference hearing or a request to convert this matter to a formal hearing should be filed with the executive director within 10 days. So he had the opportunity, if he had decided, hey, I want a full hearing, I want to bring in witnesses, I want to have a really robust hearing, he could have requested that. He never did. The statute also allows him to make a motion. 537 allows him to make a motion to convert the hearing to a formal hearing during the hearing. He never did that. So, we find the argument unpersuasive, but I also think he's waived it if the court does think there's any merit to that. Now, I want to also reference this idea that, well, the board's attorney said this and the board's attorney said that at the hearing. To clarify, that was the attorney representing the disciplinary panel of the board. We don't have time to get into the weeds, but there is a separation of prosecutorial function and judicial function here at the board. So that attorney was representing the views of a panel, of a disciplinary panel, and then bringing, and advocating to the board one way or the other. So the board is not, bound by what that prosecuting attorney says any more than a district court judge would be bound by what a prosecutor says. So we think that's a red herring. One thing I wanted to make sure I pointed out as well before we left here is that the burden of proof, and we've cited this in our brief, but it's important to note that this case is a little bit unusual because the burden of proof before this court, remains with Dr. Sajadi. So Dr. Sajadi has to show that the board's order was arbitrary, capricious, or unreasonable. The burden is not on us in this case. So I think that's an important point to make.
All right. Thank you, Mr. Poling. Any other questions by the panel? I see none. Counsel, thank you very much for your arguments. Very helpful, very interesting case. And we'll take it under advisement and get an opinion out to you. Thank you.
Thank you.